Bună ziua! Bine v-am găsit! Sper să reușesc în...
I hope I will succeed in the next 30 minutes to bring back your attention. I know I'm addressing you in the most difficult moment of the afternoon. If there is any help for you, I finished this presentation this morning at 4 o'clock, so probably we are at the same level of tiredness. 2 words about me. First of all, I am a lawyer, so you will probably also have a new perspective compared to what you've heard previously. And I am also a professor of tax law at Babeș-Bolyai University in Cluj. I teach public finance law, tax procedure and European tax law. My perspective, therefore, is a fiscal one, and somehow it is completing the perspectives presented so far by my colleagues. I usually tell my students that the tax law is one of the most demanding lovers, which would not allow you time for anything else or anyone else. Probably you've seen there are various interpretations from the notary's viewpoint, from the magistrate's viewpoint. I listened to a presentation, a wonderful presentation from an economic perspective, including many elements maybe we have never considered before this conference, and maybe it's always better to have a fresh view, a different view on things, and see how we would proceed with avoiding double taxation, for example. Obviously, maybe it's not highly interesting for a notary, because eventually taxation matters are related to the powers of the state and have only a slight impact on notaries, especially in those situations where they have to act as receivers. From this perspective, maybe it's better to start from a quote which inspired the title of my presentation, a quote from the Chronicle of a Death Foretold, Gabriel Garcia Marquez. "They seemed like 2 children," she said, and the thought frightened her, because she had always felt that only children are capable of anything. Let's discover whether the children in our story are indeed capable of anything, and whether this anything would also include something good. We should see whether this chronicle of a death foretold related to double taxation can be changed, can have a different ending from the one announced in the title.
Din această perspectivă, mi-am propus să vă reamintesc câteva chestiuni.
From this perspective, I'd like to start by getting back to basics. It's a matter related to the free movement of capitals. Still, one of the principles of the common market, as long as we are still going to have this common market, although it seems to be disintegrated, the first actor is going to escape. Next week, the Brexit will be initiated officially on March 29. But as long as we still have many other actors there, we should speak of the common market at the present tense. Therefore, Article 63 of the Treaty on the Functioning of European Union is very clear. Pursuant to the provisions of this chapter, any restrictions on the movement of capital are banned, as well as restrictions between payments, restrictions on payments between member states and between member states and third countries. So the principles appear to be clear. However, we should see to what extent they are clear for the member states, for one of the two children. In its case law, the court provided sufficient examples of free movement of capitals because, in principle, everything sounds nice. More concretely, however, we are always going to wonder what free movement of capitals means. And when we are talking about issues which are related to free movement of capitals, there are at least 5 examples we can extract from the case law of the European Court of Justice. Direct investment, even a formal portfolio investment in a holding, means one side of the free movement of capitals. And you have this explanation in C 282 from 2004, Commission versus the Netherlands. Equally, investments in real estate are another side of the free movement of capitals. C 329 from 2003, the court says that operations with financial instruments, regardless the name and the operation of the financial instruments, are related to the free movement of capitals. Maybe you did not think very much when you rented a car. In Germany, you crossed the country, you reached Belgium, then the Netherlands, and probably you returned on a different route. You didn't think that your action was related to the free movement of capital. But you purchased a cross-border, or you purchased a rent-a-car service. So you are in the scope of free movement of capital. Finally, donations and successions according to the case law, either Van Hilten, Van der Heyden, are related or fall under the scope of free movement of capital. The court, in its capacity as official interpreter of the European law, had to clarify to what extent the cases are related to a European matter, because are we discussing the principle of free movement of capital, or there are purely domestic issues? For example, in the case Van Hilten, Van der Heyden, the court says that in principle a succession is movement of capital, except for the case when its elements are limited to only one member state, in which case obviously we don't have a problem with Article 63 of the Treaty on the Functioning of the European Union. Equally, regarding donations, for the sake of symmetry, the court says that the tax treatment of donations in money or in kind falls under the scope of the treaty regarding free movement of capitals, except the cases when the elements of the transactions are limited to only one member state. The case Persh. With this introduction, or based on this foundation, we can study in time what was the case law of the European Court of Justice, and you will see that the elements of these cases are particular elements which will help us draw conclusions on the actors most often involved in these cases, about the frequency of issues occurring in international successions, and the size, including from a fiscal perspective, maybe successions with issues from the perspective of free movement of capital form the majority of cases, or there are only punctual cases which probably or might justify a certain behavior. The cases I'm talking about have been mentioned earlier by my colleagues. I'm going to try and detail the facts here, because sometimes not only the solution is the useful matter.
Cronologică. Prima afacere.
For example, chronologically speaking, the first matter is C364 per 2001, Barbier. This matter includes a ruling of the European Court of Justice in the sense that the Dutch fiscal legislation with respect to succession regarding expenses for inherited assets that are not deductible from the value of the estate if the deceased was a non-resident, while expenses are deductible for a resident, is incompatible with the principle of free movement of capitals. Maybe this requires a certain specific type of comment. We're not very used to this discussion in Romania, at least, on reducing the basis of taxation in case of successions, because most of the times we do not have such a situation, or determining the taxation basis does not raise that much debate. Very rarely are the expenses of the parties taken into account to determine the taxable base. Therefore, we do not have such issues. However, these are current matters for the German, French, Dutch, Belgian legislations and so forth. Eventually, the solution of the Court of Justice relies on the issue of discrimination, and the article in the TFEU entails this exact thing, applying different solutions to similar cases, or the other way around, identical solutions for different cases. Basically, the only aspect that entailed a different type of taxation was the residence of that person. Now, from the perspective of the free movement of capital, this raises an issue, of course. Maybe it is worth having a graphic image in mind, maybe explained by the biggest fiscal expert currently, the Van Easten, Belgian professor. He's saying that the internal market is a perfect pool table where all the balls have to travel in all directions at the same speed or without any obstacle, without any restriction. The member states should try to eliminate any hurdles, and where they do not take action or where such actions cause obstacles, the European Court of Justice has to intervene. And this is what we refer to as the role of the lawmaker in the European Court of Justice, and circumstances force the court to act as the negative lawmaker, as I said, as the constitutional court, as we call it at national level. The European Court of Justice may only say what is bad, may make recommendations, but cannot regulate, so that a solution be provided to the problems that it has identified. Furthermore, the ruling dating 23rd of February 2006, case C 513 per 03, the Van Hilton Van der Heiden. Quite a bitter finding. With the lack of a fiscal harmonization, member states are free to divide their right of taxation. As you know, at least partially, the Union, as far as tax matters go as well, is built on, let's say, concessions from the from the member states, or compromises. The same Van Eastendal said that member states give up with quite the difficulty to their tax sovereignty, quite plastically put, as if it were a matter of their own virginity. This is the issue, bottom line, of transferring jurisdiction between one member state to the other, or between member states and the EU. And differences are quite significant, especially with respect to direct taxes, where member states are stubbornly opposing any type of transfer of jurisdiction. In this case, says the court, however, we have to look into how the treatment applied by the Dutch fiscal authority infringes the principle of free movement of capital. A Dutch document from 1956 presumed that the citizens emigrating from the Netherlands continued to be Dutch citizens, or continued to be subject to the Dutch fiscal legislation for another 10 years, starting with the date when they left the national territory. From this perspective, the court reviews both the restriction in the Dutch fiscal legislation and also the open possibility, the possibility provided from the new state of residence of recognizing the tax paid in the Netherlands. And in this case of 2006, the court formulates a very clear and updated ruling. If we cannot avoid double taxation, it is acceptable to find some sort of compromise to reduce that fiscal burden, but through a fiscal credit, that is, of reducing in another member state the taxes paid in another member state, is an acceptable scenario. Maybe the compromise, as I said. There is also the unacceptable scenario when the same income is taxed twice, or there is the completely acceptable scenario in which the income is not taxed at all. Think, for example, of the situation of a Romanian citizen performing an activity and receiving a salary in the United Arab Emirates. Now, according to current provisions in the United Arab Emirates, there is no taxation because it performs the area in a free, the activity in a free area, and they survive based on the consumption, not on the revenue or the taxes applied there. And the Romanian citizen is not taxed because the revenue acquired abroad from independent activities are not taxed in Romania, irrespective of the fiscal regime in the other member state. Of course, the lawmaker did not think of it like that. And there's just a matter of time, because it's one thing to exempt taxation on a salary in Belgium with 1,000 euro per month, and it's another thing to exempt taxation for an individual performing an activity and receiving a salary in a free area in Dubai and maybe producing 500,000 euro per year. It is a radical a statement, but these cases do come across. What is interesting in Van Hilton, Vardenheiden is that the European Court of Justice refers specifically to the template convention OECD. And tries to explain the behavior of the Dutch fiscal treatment by referring to a provision in this template convention, showing that it was anyway acceptable if the deceased had passed away shortly after emigrating. So what the court says, and it resonates with other fields of the tax law, in the sense that the member states should only prevent fraud. The changing of the fiscal domicile to receive fiscal relief can be sanctioned, but it cannot be sanctioned generally in the sense of exercising movement or freedom. Now, moving further, a case from an area with sometimes excessive taxation. The case is 464/05 Maria Gertz and Dennis Vogten. A discussion about transferring stock in a company. Of course, in the case of a succession, that depends on the restrictions of the Flemish legislation, saying that there is a exemption or relief from the taxation of the succession if the activity had performed for or had existed for at least 3 years prior to the death, and they had a minimum 5 employees in the Flemish region. Now, as you know, they have a very protective taxation legislation in the sense of keeping all assets in the property or in the possession of the population in the Flemish area. Now, the company in this case met all the requirements in the Flemish law, but in the Netherlands. So the court found it easier to rule on the issue on the matter of freedom of settlement, saying that for the simple fact that I settled in the Netherlands and not in the Flemish area in Belgium, there's a discriminatory fiscal treatment against me. That's the main issue for the freedom of settlement, with the secondary impact on the free movement of capital. But obviously, if I am not encouraged to express my freedom of settlement in another member state, I am not encouraged to simply make the money travel from one side to the other. Another issue, case from the 17th of January 2008, Theodor Jagar. This is a debate on the assessment or the evaluation of successions. Now, I'm coming back to what I said earlier. Maybe these are issues that for us in Eastern Europe are not quite fashionable, so to speak, that regarding the basis of the taxation, the assessment of the assets, these are matters that we easily disregard. Do you see, in each of these cases, there is a debate that maybe you hadn't thought of before. The French-German situation, assets of a German citizen located in France, subject to double taxation. Of course, the discussion had not existed if the member states had divided between them the jurisdiction of taxation. But since this was not the case, because there was no convention, or there was a convention to avoid double taxation, but this was not perfectly functional in this case, Germany in this case taxed with more difficulty the assets in France. So it only acknowledged partially the tax paid in France due to the assessment methods that differed. This is Europe's major issue currently, that is presenting its situation in a very disadvantageous way compared to the other states. As you know, generally speaking, taxes in Europe are 10 to 15% higher for businesses than compared to the US, Japan, South Korea, and partially this also comes from the fact that we speak many different languages, that we apply different accounting systems or assessment or taxation systems that are completely different. And again, as a tangent, if we to use a twofold approach, one of the measure is of the European income, and the other would be of a corporate income tax that would solve such an issue. But in our case, starting from the finding that the immovable assets in France had a higher taxation than if located in Germany, the court ruled on a clear differentiation between the taxation and discrimination. In 2008, the court ruled on the matter C11/07, Hans Eckelkamp and others. Basically, a similar issue with respect to debts that can be applied in a certain member state. The capacity of a resident of a certain state again yields a different tax treatment. Just because the deceased was not Belgian at the time of the death, the fiscal treatment is more disadvantageous. And this is again where issues occur. Germany, France, Belgium, and the Netherlands currently. These seem to be, if not the only member states with these issues, among the few. In September 2008, the court also rules in the matter C43/07, Arensikken, with a matter generated by the obligation to pay a certain obligation. Now, Mr. Arensikken in Italy divides his assets between the surviving wife and 4 sons, but the wife receives real estate in the Netherlands. She has to provide financial compensation to the 4 sons to establish equal shares to each of them. When tax is applied for everybody in the Netherlands, the 4 sons are taxed at the value of the assets, and the wife is taxed at the value of the real estate, which does not decrease that amount paid to compensate the others, so that cash payment, because she didn't have, she wasn't a Dutch citizen at that time. Again, a situation of discrimination from the perspective of free movement of capital. A rather often case, the situation in which a 80-year-old something German moves to Spain, passes away, and there's an issue of sharing his assets. Spain has one of the main issues in this respect, especially with respect to the German legislation regarding succession. The matter of Madame Bloch is in the sense that she has to pay taxes for real estate both in Spain regarding the location and in Germany regarding the criterion of the citizenship of the deceased. Madame Bloch challenges the obligation, raises the issue to the court, and the court comes back to a previous explanation in a previous ruling saying that yes, indeed, this is a double taxation, legally speaking. Indeed, the persons in this situation have a higher obligation, but the matter cannot be handled by the court. This is an issue that depends on the member states, and the court also indicates to the text relevant at the time, Article 293 in the treaty, allowing the member states to conclude conventions to avoid double taxation. The court finds that there is no such convention, that there is no general provision in the treaty forbidding this type of treatment, and decides to the detriment of Madame Bloch, which Antonio actually referred to before, the lack of those conventions to avoid double taxation within Europe, where the at least conceptual differences are not that significant compared to what happened a couple of hundreds years ago in the Roman-German Empire. So Europe was always an area of taxation. Wherever you could, you would apply the biggest taxes ever or possible. And maybe that's why we understand from this perspective Brexit as well. And also the conception on fiscality of the British Church. There is a doctrine, an Anglo-Saxon doctrine from the 30s, saying that nobody can force you to pay the highest taxes possible, irrespective of how much your neighbors and the IRS might hate you for this. And the theory is conceptually at the basis of the fiscal theory. This is the theory that Europe and all member states stand against stubbornly. To what extent this might be a fashionable topic, I do not know to tell you, but as the idea, you can see two different opinions from this perspective. Just a couple of rulings. I promise to not take too much of your time. The C 510/08, the Vera Matner issue, again the differentiation between the situation of residents and non-residents. The ladies had maybe a particular situation, although their asset was inherited was in Germany. They lived in the Netherlands. The mother for 50 years, the daughter for 35 years. And the court believes that in such a case, the limitation of the free movement of capital is not justified, since it's not an internal situation, because the asset was inherited by one Dutch resident from another Dutch resident, although they lived in Germany. This is a ruling from the 10th of February 2011, the C 25/10. also referred to in the previous discussions. Maybe the last two are of a greater interest, and also given the high value of the debated assets. The mission work receives a legacy from Madame Renardi, a Belgian citizen that never left Belgium throughout her entire life. However, due to the fact that the rules in the Flemish area couldn't be changed, the transfer of ownership to foreign citizens, although an association, is taxed according to the Flemish fiscal legislation, which is 80%. Mission work asks for the 7% tax to be applied. The fiscal authorities in Belgium do not accept, because they invoke the right to protect the organizations which perform an activity for the Belgian community. This disposition was dismantled in the court in the motivation, explaining that the purpose of the fiscal legislation in Belgium could not be reached through such a super-taxation measure. Of course, applicable to that legacy in favor of a person that had no relationship, had no kinship with Madame Renardi. And the last, maybe the most important case, financially speaking, the matter of the Carrefour lawsuits. Olivier Paul-Louis Haley, Julie Jacqueline Barthes Marie Haley, and Marie-Joëlle Armel Haley. The same matter. The succession entails a transfer of a significant number of Carrefour shares. Basically, the two parents die. The Carrefour stocks are assessed at 28.31 euro per stock. Apparently 35% below the market price at that time. The succession is handled in 2004 and 2005 with the payment of the proper taxes in Belgium. In 2008, the fiscal authorities apply a subsequent tax control and say that we reassess those stocks. Their value was in fact 43.55 euro per stock. A reason for which we overtax the error. Apparently this is an issue of procedure, an error of procedure. They invoke the lapse of the possibility to reassess, saying that the period was 2 years from the Belgian legislation, also substantiated by the fact that the actual management resided in Belgium. And fiscal authorities say that the period is 10 years because the management is in fact in another member state, in France in this case. However, the court rules that this restriction is completely arbitrary, and you cannot apply completely different approaches for identical or similar cases with respect of the free movement of capital. And this is maybe the matter that shows at the end of 2011 the importance of litigations that are brought before the court. And maybe this is a conclusion that we can draw from the fact that people come to court, the European Court, with such matters. Those cases from 5 member states of the European Union are matters of a different size, but this really shouldn't influence our judgment, because any restriction, as small as it might be, to the free movement of capital is an obstacle to that. So it's an obstacle to that perfect pool table that I've described, and it should be dismissed as such. Now, what does the European Court of Justice do? What does the European Commission do? They do a lot. The discussions rather occur in September 2011, because already in December 2011 the Commission provides a recommendation for the Member States to take the necessary measures to avoid double taxation with a set of associated documents that we somehow categorize as soft law. As you know, the opposition is the hard law, regulation, directive that forces certain measures on the Member States, and the soft law saying that it is recommended that without any sanctions being applied if Member States do not take this recommendation to practice. In Europe, since 2003, there is a code of conduct with respect to company taxation, and it never stopped Luxembourg from concluding about 500 rulings with various giants or tycoons such as IKEA or Pepsi to negotiate their taxes and to make sure that the taxes are collected in Luxembourg and not somewhere else. It is rather peculiar to hear Jan-Claude Juncker, the president of the of the Council of Ministers for 10 years now, referring to Directive 1164 per 2016, which is against the disruption of profit and wanting to keep profit in the states where they are actually achieved. Comment closed. Now, as I said, the Commission only makes a set of recommendations in 2011. Of course, in a certain context, maybe stemming from these three conclusions. The Court of Justice of the European Union is the only active player trying to ensure a level playing field, removing restrictions from the internal market. The Member States do not do anything or barely anything. And again, a comment so that you better understand the context and that you manage to differentiate between important matters and less important matters. Think about the fact that the European Union has yet to solve the matter of contradiction between European law and bilateral treatments for protecting investments, such as Romania's recent case. Scandic Distilleries, or the European Food Scandic Group, located in a disadvantaged area, benefiting until 2004 from tax reliefs. In 2004, says the speaker, the integration in the EU shuts down that relief for the company that continues to have obligations to keep the employees for another 10 years. In quite the genius move, the shareholders give up their Romanian citizenship, have Swedish citizenship, and invoke in an international center of handling complaints, ICSID, the bilateral treaty for protecting investments between Romania and Sweden, and they're saying that my Swedish investment in Romania has to be protected. ICSID decides 2013, I believe, that the Romanian state has to pay about $100 million compensation to the two Swedish citizens. The legal conflict on the one hand, because the Commission asks Romania not to enforce the ruling because the treaty protecting investments between Romania and Sweden is incompatible with the European law. On the other hand, the company asks Romania to enforce a ruling of an international court whose jurisdiction has accepted the effects, because with enforcement willy-nilly, the Romanian state has to enforce at least some of that ruling. The Commission asks the European Court of Justice to sanction Romania for breaching, not just Romania, but the three states, so for breaching the obligations in the treaty because it did not waive or terminate the Convention of Mutual Protection of Investments. So, although it exists, this is incompatible with the European law, and maybe thus the reticence of the member states to use such conventions of avoiding double taxation. Certainly, the Commission in 2011 only makes recommendations that do not relieve the process and only does not take clear responsibilities. It will only states to the reassessment to be carried out in 2014, which is performed by the European Fiscal Confederation through an opinion statement number 12 per 2014. In this opinion statement, there are some key elements, I would call them. On the one hand, the European Fiscal Confederation highlights an idea that was mentioned here before. We cannot avoid double taxation, therefore, we have to limit our actions to what we can have, to a system of at least general allocation of competence or jurisdiction between the states, doubled by the fiscal credit, that is, acknowledgement of taxes paid in other member states. Why not to acknowledge it is the rather rare case in which you have conventions to avoid double taxation with respect to income tax. To take an example that I referred to earlier, Romania has a convention to avoid double taxation with the United Arab Emirates. The dividend income in the UAE are taxed in Romania. In the convention to avoid double taxation with the US, very often income in Romania from selling photographs online are taxed both in the US and in Romania. 10% in the US, the difference, the remainder up to 16% in Romania. And in general, the online generated income, which seems to be that emerging income that is taxed according to these conventions of avoiding double taxation, which, mind you, not just avoids double taxation. I think it's a convention of allocating the jurisdiction of the right to tax and as a byproduct of avoiding double taxation. So that double taxation is just a pretext with respect to the right to apply tax. This fiscal confederation continues to say that it doesn't stand by the tiebreaker rule that the EC suggests. The EC suggests that failing an agreement between the member states, an arbiter should determine the jurisdiction. However, the solution for tax experts is simple. The arbitration lasts. So this could only be seen as an adjustment. That is, if member states do not decide within a reasonable period of time how to divide their tax jurisdiction, a mandatory proportion, let's call it, regulated by the EU, is applied with respect to the allocation of tax income. you should keep in mind the model for taxing interests. As you know, since the accession, for us, for interests generated in another member state, mandatorily the tax is divided 75% the originating state, 25% the consignee state. So if your deposits are transferred from Romania to Sweden, the Romanian state continues to have jurisdiction to tax interests for your bank deposits and takes three-fourths of this income, of this tax. What this commission also suggests is a mandatory regulation or type of regulating that everybody refers to, the OECD convention, with a very simple rule that was raised several times here. The jurisdiction for taxation for real estate under succession to be under the jurisdiction of the location of that state, and for movable assets to belong to the state where the deceased had their habitual residence. It seems, from the debates, to be the most often used solution. Yes, it might be possible if the Commission regulates on the matter, or would suggest a regulation on the matter, for this to be the chosen way. There aren't, however, that many indications encouraging in this respect. Quite objectively put, the EC and the EU have bigger fish to fry currently, so consider Regulation 650/2012 as quite the progress on the matter, but do not ignore that from a fiscal perspective, the chances that something happen in the near future are rather slim to null. The lack of transparency, the general issues, and money, or the stake, better say, because the states making significant revenue from taxing successions or donations are not that easily swayed to give them up, at least partially, are currently making such a regulation highly unlikely. Maybe this is the conclusion from Marquez, saying that there never was such a foretold death. Maybe the conclusion of this title, to somehow keep the same tone of the title, is, I think, best chosen. Thank you. I hope at least partially I managed to get your attention, and please give the same attention to Professor Popescu, that is coming up next, and for sure has more interesting things to say. Thank you very much.